Hello, everyone. This is Tom Fox, and welcome to the FCPA Compliance and Ethics Report, Episode 14. Today, it is my distinct privilege and pleasure to have our great FCPA colleague, the FCPA Professor, on, Mike Kohler. We're going to have a conversation about some of the things that he's been thinking about recently. And with that, Professor, if I could ask you, what are some of the things that have been on your mind lately?
Well, first of all, Tom, thanks for having me and for doing this public service of allowing people interested in the FCPA to both talk about the issues and to watch other people talk about the issues. My career choice, I guess, gives me the opportunity to think a lot about the FCPA and FCPA enforcement, and probably some people will say think too much about it. But one issue several issues that have been on my mind of late are actually some issues that go back to my practice experience as well. And one issue that I think it's reasonable and appropriate for taxpayers to ask is, what do DOJ and SEC FCPA enforcement attorneys actually do? You know, at a recent conference in Washington, D.C., we were told that there are over 20 full-time DOJ FCPA enforcement attorneys. And that's not including when, in the very rare instance, the DOJ is put to its burden of proof, they largely farm out the cases to local U.S. attorneys and assistant U.S. attorneys. And at the same conference, we were told that the SEC, amazingly, has approximately 36 full-time FCPA enforcement attorneys, not including, it was said, people outside of Washington, D.C. who may dabble in the FCPA as well. And I think it's, again, an appropriate and reasonable question to ask what these people are doing on a daily basis. And indeed, in attending conferences of late, a lot of people are asking this question and whispering this question on the sidelines as well. And I'd be the first to admit that obviously you can't judge the FCPA enforcement program solely by the enforcement actions alone. You know, for instance, this year there's only been 4 FCPA enforcement actions. And I'm not at all suggesting that that is the only way to measure the output of the FCPA enforcement program. But, you know, given that most of these cases are voluntary disclosures, given that in a voluntary disclosure the DOJ and the SEC has literally handed, chronological documents and witness interview memos, so on and so forth, you ask me what's on my mind, and it's always been on my mind, and more prominently after hearing these recent comments, just as to the number of enforcement attorneys there are, just the general question of what do they do, and I think it's a question on the minds of a lot of people.
Well, let me play a little devil's advocate then. Do you have any thoughts on how you might try to quantify, measure, or otherwise analyze the question you've just posed?
Well, I really don't know without getting a hold of people's schedules exactly how to go about that. I mean, anecdotally, you could ask people, at least as to the top officials, we do know when they're speaking at events, which is very, very, very frequently, and I've been critical of the DOJ and SEC enforcement attorneys essentially allowing themselves to be pawns in the for-profit conference industry world. You know, why should anyone have to pay $2,000-3,000 to hear our public officials speak at some of these many and numerous FCPA conferences? You know, the conference organizers know full well that the way to get people there and to pay these rather high fees to hear the enforcement attorneys speak, granted it's only one panel out of a perhaps 1 or 2 day program, is to actively market the fact that you're going to hear, some specialized insight, from the DOJ and SEC officials. And for the life of me, I don't understand why the officials allow themselves to be used in that way.
Well, from my perspective, I think it's a great service to the FCPA community. You do point out that they're always a minority in the minority of the overall number of speakers. Uh, there are lots of reasons to go to conferences. Certainly, to hear the regulators speak is one of them. But then I would posit that if you and I were at a conference and you and I heard a regulator speak, we would probably speak hours analyzing what they talked about, and that's the kind of interplay, exchange, discussion among colleagues that I think is even as valuable as hearing the regulator speak is being able to talk to my peers about, well, what does it mean? What does it mean going forward? Is it inconsistent with things we've heard in the past? So I think it's a valuable service. I agree that, well, certainly I think the conferences are too expensive, but that's what the market will bear. So people like us either have to pay for it or get on the speaking panel as well.
Well, I'm not at all suggesting that these conferences don't have some value in certain respects. I've just often been critical, and other people have as well, the notion that when the public officials speak, people that earn a salary from the taxpayers, why should you have to pay to hear that? I think that's the issue. I mean, I agree that the conferences and the networking opportunities and the discussion of ideas is of value to conference participants.
Uh,
So, big picture question, I think it's a reasonable and appropriate question to ask, given the number of enforcement officials there are now in the specialized DOJ and SEC enforcement units.
um, Over the past 3 or 4 years, certainly since I've been actively working and blogging in this field, the numbers I've seen or heard bandied about or of open enforcement actions have generally been between 100 to 140, perhaps as high as 150. Isn't it possible that an increase, and certainly one of the complaints of almost all FCPA practitioners is the length of time it takes from the time an enforcement action begins until conclusion, usually multiple years. Isn't it reasonable that some of these additional lawyers might help cut that time down?
Well, most, as you know, FCPA inquiries are essentially outsourced to the company's counsel. The reason those enforcement actions from the point of first instance of public scrutiny to any enforcement action takes that long is largely because of the where else question and the notion that the company is doing a worldwide review of its operations. That's not being done by the DOJ or SEC enforcement attorneys. And indeed, when the DOJ needs to do some field work, it relies upon the FBI to do that field work. So, yeah, I mean, I hear the numbers that are often talked about in terms of the number of open investigations, but, you know, again, I think the substantial bulk of those are voluntary disclosures where the company and its lawyers are doing the factual investigation and the witness interviews, so on and so forth. Now, again, the DOJ will say we always cross-check and verify that information, but I've never spoken to an FCPA practitioner that really got the sense that that was indeed going on. Now, again, we don't know what's going on behind the scenes, nor given that the DOJ is a law enforcement agency, am I suggesting that we have a right to know, but I'm just posing the big picture question, the question that is on the minds of a lot of individuals in this new era of FCPA enforcement, and that is just what is the DOJ's specific FCPA unit and the FCPA and the SEC's specific FCPA unit. What do they do on a daily basis?
Well, and here's the quandary I would have in response to that question. The minute you ask that question and the minute you start to answer it in terms of some sort of quantitative response, that becomes the measure. And if the measure is the amount of dollars collected by the FCPA unit divided by the number of lawyers, that becomes the standard. Not are we doing the right thing, not is it justice. And I absolutely don't want our government regulators graded on the amount of money they bring in, the amount of scalps they bring in, or anything else along those lines. And my fear is if we have to move towards a quantitative justification for the number of lawyers, you're going to move towards that. And I don't see that as a good thing.
Well, I completely agree with that statement, and that's why I began the discussion by saying that I completely understand how you cannot exactly measure the output solely by enforcement actions alone. But I'll just raise the issue, Tom, that the DOJ and the SEC measure themselves in this quantitative way. I mean, how often do you see press releases by the DOJ or SEC talking about the amount of financial intake they have? How often do you see DOJ and SEC enforcement officials talking about the numbers? So they're the ones that are talking about the numbers, whether in press releases or public statements. And if they're going to talk about the numbers and raise that issue, I think it's appropriate to ask follow-up questions and perhaps ask some big picture questions associated with that.
Well, I guess I see those numbers, and I'm less concerned about somebody bandying a press release saying we got the biggest, we got the most. Here's a large number, as opposed to individual lawyers being graded on how much they brought in, and that's
Yeah.
the difference I see. Okay, well, one of the things that you continually raise, I shouldn't say not that you just raised, but is the amount, nature, quality, whatever the right term might be, of information about the FCPA that's available in the public domain. And you and I have certainly agreed upon the need for, or it would be very helpful to have greater information regarding declinations. Are there other areas you think that there could be a greater quality of information in the public domain?
Yeah, I think that if the people who are actively writing about the FCPA would perhaps read original source documents and do due diligence on some of the things they're putting in the public domain, I think that could definitely increase the quality of information out there. Look, like you, I run FCPA searches literally, every day in connection with running my FCPA Professor website. And it always amazes me that, like, literally an hour, for instance, after an enforcement action is announced, where the original source documents, like, literally consist of, 100 to 150 pages, people are already talking about this. There is no way they could possibly read these original source documents prior to, talking or speaking about an issue. So I think everyone who is writing or talking about the FCPA has a duty, if you will, to actually be informed on the issues and to read the original source documents and not just simply regurgitate or advance press releases, et cetera, et cetera. And another thing where I think the quality of information could be improved is there's a lot of undisclosed conflicts of interest when it comes to FCPA information. And here I'm not talking about, law firms that are writing client alerts. I mean, I think it's quite obvious to any person reading that given the law firm's letterhead, et cetera, that, hey, there was probably a business purpose connected with drafting that client alert. I'm talking about others who are writing about the FCPA in what appears to be an objective sense, when in reality is they're for-profit businesses. And also, for instance, the mainstream media. In this new era of FCPA enforcement, a lot of the mainstream media now has risk and compliance divisions within their overall media company. So I think there's such an inherent interest to portray the FCPA and FCPA enforcement really more than it is, to portray it to be this boogeyman that I think in many cases it's not always that case. And I just think that the nature and quality of information in the public domain needs to be properly vetted and put out there in a responsible, transparent manner. And I do have some concerns that's not occurring.
Well, I would certainly agree that there's a lot of information, a lot of perhaps even disinformation, and certainly there's a lot of people who don't read the source documents as certainly as thoroughly as you do before you or I or others would write about them. Do you really feel like that the people who read what's in the public information are confused by commentators who are less thorough or less diligent in their research?
Yes, I do think there's a great amount of confusion, and all you need to do is pick up the major newspapers in this country to recognize that.
You know, I've heard you talk about newspaper commentary before, and I guess I feel like that for the most part, newspaper reporters are not lawyers. They don't have the depth of understanding that we have. They don't have the ability to write the length of papers that we have, and that I think they do as probably as good a job as they can with the length of article and the detail that they can write for a newspaper, not for a more scholarly commentary.
Well, if you have space restrictions, does that provide an excuse to not have complete and accurate information? I mean, I understand there's space restrictions when you have a hard copy newspaper, but I'm just talking about completely false information sometimes. And the situation that immediately comes to mind is it was probably 6 to 9 months ago when Las Vegas Sands disclosed in an SEC filing that the company had discovered some issues under the FCPA's books and records and internal control provisions. Now, you and I and other sophisticated viewers know that there is a fundamental difference between the FCPA's books and records and internal control provisions and the anti-bribery provisions. So what happened when Las Vegas Sands made that disclosure? The New York Times, the Wall Street Journal, ProPublica, other respected agencies, the headlines literally read Las Vegas Sands admits to violating foreign bribery law. Well, that's not what the company's disclosure said. But given how information spreads in this new age, this was broadcast literally all over the world when if the people who looked at this and first wrote these stories had any level of knowledge regarding the FCPA would clearly understand that that's not what Las Vegas Sands disclosure actually said. Now, I know this is just anecdotal and just one example of perhaps many, but I do think there is an unhealthy amount of misinformation in the public domain about the FCPA. And I do think that this misinformation causes much confusion and indeed much unneeded hysteria about the FCPA and FCPA enforcement.
Well, I guess I do have to concede that I have been involved in a few instances where I thought reporters perhaps made things a little more sensational than I really thought they were. I guess I'm just not too fussed by that. Newspapers have
Like
been doing that for a long time.
like I said, Tom, my position provides me a lot of time to think about issues, and some would argue think too much about issues.
Uh, All right. Well, one of the next topics that I wanted to raise with you is I think one of the things that you've been fairly outspoken about is your view that the government has contradictory policy regarding FCPA compliance. Is that something that you could expound on a little bit?
Yeah, I'd be happy to. You know, we're now approximately 1 year into the FCPA guidance that was issued in November of 2012, and as I wrote at the time, there were some very sensible compliance statements, both in the FCPA guidance and in connection with the guidance press conference. Both the DOJ and SEC representatives said we are most interested in companies spending their compliance resources effectively, maximizing the investment. They tried to dispel this notion that minor payments are the focus of FCPA enforcement actions. The guidance specifically says that cost of compliance is a relevant factor in connection with the internal control provisions, which indeed that is consistent with not only the statute itself, but other legal authorities such as legislative history and the only actual substantive decision as to these provisions. So on one level, the DOJ and SEC, to a lesser extent, I guess, is making some very sensible compliance positions known. But at the end of the day, when you read the enforcement actions, it's very common to have allegations literally concerning tea sets and kitchen appliances and karaoke bars and bathhouses and cigarettes. And these are not fabrications, that you can go into the actual enforcement documents and read about this. Now, the DOJ and the SEC say that companies should view these resolution documents as what the enforcement policies are and act accordingly. And I'd be the first to concede that, of course, in these enforcement actions, which include these rather minor and trivial allegations, that was not the reason for the enforcement action in the first place. But I do think by including what I'll call these non-determinative allegations in the enforcement actions, what the DOJ and the SEC are essentially doing is contradicting that sensible cost of compliance guidance that they're putting out there. Because you know how it works, Tom. The industry is going to take the enforcement actions, use them as marketing tools, and portray the notion that companies are literally being the subject of enforcement actions because a Chinese sales employee may have provided cigarettes to somebody. You know, it's often amazed me. I do some, business roundtable discussions and other non-public events when it comes to compliance issues, and it always amazes me what the compliance officers and in-house attorneys from large, sophisticated companies are actually worried about and thinking about on a daily basis. And I think the DOJ and the SEC could help companies in this area by only including allegations in an enforcement action that were the driver of the enforcement action in the first place.
Well, with regard to some of these smaller ones, and of course my favorite is the roses given to the wife of a Chinese governmental official, so that we can actually claim that a few roses may have caused an FCPA violation. But more seriously, these are typically in books and records violations, and that they're not substantive criminal FCPA violations prosecuted by the Department of Justice. And it seems to me they're just sort of throw-ins on an SEC civil complaint. So I guess I look at those and just find those to be not as important a piece of information, although those are the ones that people remember, whether it's a box of chocolates, a dozen roses, or a trip to the bathhouse.
These are not just SEC civil complaints that you find these allegations in. These are in DOJ, NPAs, and DPAs as well.
So there's, I guess we probably disagree on that point as well.
Well, I can send you those documents if you're interested.
I'm always interested. But let me end with this. You, of course, have been writing your nom de plume as the FCPA professor. You've been teaching FCPA both in business school and now at law school. Over the past, I guess, 2-3 weeks, you've had on your blog post some surveys that you have done of your students. So what I really wanted to ask you is, what's it like being a professor, now a law professor, teaching an FCPA class, and then go into the surveys what of your students that you've taken and you've posted about, and can you tell us why you decided to do that and what some of the results that you've seen that surprised you or didn't surprise you?
Yeah, I mean, on one level, teaching the FCPA as a legal substantive topic is very difficult. You know, when you think of a typical law student is well versed in legal authority, in case law, in a traditional old-fashioned adversarial process in which if someone disagrees with a prosecutorial decision or theory, there's an adversarial process by which that can be properly vetted. As you know, and your viewers know, when it comes to the FCPA and FCPA enforcement, there is not much legal authority out there. I mean, what I mean by legal authority is obviously the statute, the legislative history, and any case law precedent. There's just not much legal authority out there. There are some. There will be more in the future, but there's not much. So essentially, you're teaching the students non-legal sources of authority and information, which is completely counter to how a typical law student or any a student generally goes about how they learn about a topic. But the class that I'm teaching is obviously more about the FCPA because understanding the FCPA and FCPA enforcement, of course, requires a knowledge and understanding of DOJ policy, of SEC policy, of DOJ resolution documents, SEC resolution documents, respondent superior, the realities of the global marketplace, et cetera, et cetera. It's a very, for a small law school that I teach at, is a very popular class in terms of the number of students. Um, the students are very interested in it for many of the same reasons you and I and so many others are interested in the FCPA. It's a criminal topic. It's an international topic. It implicates, in many cases, foreign policy. It's just a very interesting topic. Now, I do think as the survey data I have published that has been gathered anonymously from my students, that there is some questions and concerns regarding this new era of FCPA enforcement. Because so many, I think, view this topic as, okay, bribery. Bribery is bad, therefore all attempts to enforce bribery laws must be good. Well, that's not a very informed or sophisticated or mature view of what indeed is going on here. So there is a healthy amount of skepticism as to this new era of FCPA enforcement. And it has been pointed out to me that the survey data is only a reflection upon my views because I'm the teacher. Well, not only is that incredibly critical of my teaching style without actually being in the classroom or actually reading my book, it sort of demeans my students and their lack of capacity to have independent thought. Given that these are anonymous survey examples. The person who said this to me, I told them, well, would the K decision be any different if I'm not teaching it? Would the Carson foreign official jury instructions be any different if I'm not teaching it? Would the FCPA's legislative history be any different if someone else was teaching it? So I think, if there's any skepticism of the FCPA and FCPA enforcement, it's like sort of viewed as, oh my gosh, what's wrong with you? Are you not thinking straightly? But I think it's very good for future lawyers representing clients in the international marketplace to have a complete and accurate view of legal authority and non-legal sources of information that are out there concerning this new era of FCPA enforcement.
Well, Professor, we're at the end of our time. I wanted to end with if people wanted to follow up with you or perhaps visit with you, could you give us your email address so they could contact you?
Yeah, my website is fcpaprofessor.com, and on the website there's contact information, fcpaprofessor@gmail.com. I'm always happy to talk to you and others about the issues.
And I'll just end by telling anyone listening, if you don't follow the FCPA Professor every day, you should. And it should be one of the first clicks you make on your FCPA journey during the day because it's always quality information. It's always topical. It's always interesting. As his name indicates, he takes a view at it from the legal perspective, and he's the leading person doing that. So with that, I'm going to say thanks very much. This is a ton of fun, and we're going to have to do it again soon.
Yeah, thanks, Tom.